Brett Hudson.
Thank you, Mr Speaker. It's a pleasure to rise in support of the Official Information Parliamentary Under-Secretaries Amendment Bill. Now, one of the things we hear quite often as a first-term MP is the value of the Select Committee process, an opportunity to reflect, to listen to submissions, to reconsider one's position, and just occasionally to change it. And this is the position we find ourselves on this side in this second reading of this bill. We had grave concerns at the introduction of this bill that it wasn't necessarily actually going to meet the objectives set out, but particularly that it would blur some constitutional distinctions, some roles within Parliament, and that it could be a slippery slope to other things. But hearing the submissions and the advice from officials and discussing it as members of the committee, I think we all reached a position that, in the interests of transparency of this government, in this instance at least, trumps the potential, because it's by no means absolutely certain that by permitting this bill to pass that we will destroy the constitutional separations between roles. So that in the interests of serving transparency in government and transparency to the public, that would outweigh the potential that we could in some way blur those distinctions, because the distinctions are real. And it has been mentioned by several speakers this evening, Mr Speaker, that in the first reading of this bill, a number of members in this House made incorrect references to the executive. And I will put my hand up on review of the Hansard on one of those. But there is a very, very clear distinction. In fact, two members tonight, one for the Greens and one for the New Zealand First, failed to acknowledge that, possibly failed to understand that. In the executive, there exists the executive and there exists the Executive Council. The Executive Council is the group that advises the Governor-General. It is the Executive Council that has the Governor-General execute orders in Council. So those acts or actions of government are outside of the acts that Parliament passes. Now, all ministers are members of the Executive Council. They are also members of the Executive. The only members of the Executive that are not members of the Executive Council are Parliamentary Under-Secretaries. This distinction has existed in this country since at least the early 1980s. Now, of the submitters that appeared before the committee were included the Law Commission, represented by the Honourable Sir Grant Hammond. And many of them, and particularly that submission, made the point that they felt that including the Parliamentary Under-Secretaries was within the spirit of the Official Information Act, and that it would provide that level of accountability and insight over the actions of the executive. But one element, they also pointed out actually that members in this House had made that incorrect distinction in the first reading. They talked about Parliamentary Secretaries not being members of the executive when they are, but they are not members of the Executive Council. So what we should have said, myself included, in the first reading was the distinction was the Executive Council, not the executive. What they hadn't considered when they did look at saying, well, actually, this fits within the spirit of the OIA, what they had not considered was why had Parliament originally made that distinction, and what had Parliament intended, and what had members of Parliament spoken about in that distinction between being a member of the Executive Council, a minister, and therefore very clearly, because of the language of the Official Information Act, subject to it. What's the distinction between that group and members of the executive who are not members of the Executive Council and who have never been, up until perhaps the third reading of this bill, have never been subject to the Official Information Act? Because another thing that I think we would all agree on is that Parliament does things for a purpose, and also, and under consideration, when it doesn't do things, it doesn't do those things for a purpose. So we asked officials, well, I asked officials, to look back at the Hansard, at various public commentaries around the time not only of the passing of the Official Information Act, but in the subsequent years to it in the 1980s, because the Parliamentary Under-Secretary role was well used in that period, particularly the period of the Longi government. In fact, two members of this Parliament, the Honourable Annette King and the Honourable Peter Dunn, were both Parliamentary Under-Secretaries in the 1980s, and therefore neither of them were subject to the Official Information Act in the discharge of those roles. Interestingly, that some years wind the clock a few years forward, and now both of them are going to be in favour of the role they once held, now being subject to an act that wasn't when they held those roles. And so we asked them to have a look at the record of Hansard and other public commentaries to say, right, what comment has ever come out in that period that gave some measure that Parliament thought, oops, we've made a mistake. We have these Parliamentary Under-Secretaries, they are not captured by this Act, oops, perhaps we should either change it or at least reflect on the fact that that what we've done doesn't include. And they found the sum total of 0 utterances to show any sign at all that parliaments in the 1980s, including the parliament that actually created the Act, but subsequent as well, that members of Parliament considered that somehow they'd got it wrong. Somehow this Act passed that was to give greater transparency, insight into what government was doing, and to share that with the public. There was no sign at all that those parliaments thought that they had got it wrong. And from that we can deduce quite simply that the Official Information Act was never intended to apply to members outside of the Executive Council. It was never the spirit of the Act to include Parliamentary Under-Secretaries. So we now find ourselves in a position where we are considering doing that. And I think it's important in the reflection on it that we actually look at what we are really doing here then. What we're looking to do is not say that it's ever been the spirit of the OIA to include Parliamentary Under-Secretaries. What we are saying is that the desire of the public, in the interest of transparency today, that we are choosing to evolve the Act and its intent and its scope of coverage beyond what had been intended up until this point. And so we can do so in the knowledge that we are evolving a piece of legislation, we are providing greater transparency to the public, we will include people like David Seymour within the ambit of questions under the OIA. That will give greater and more ample opportunity for the public to seek answers that we hold, quite frankly, could be sought anyway, because, as has been covered again, Parliamentary Under-Secretaries receive their delegations from ministers and they are responsible to those ministers for the discharge of their duties. We did ask, during the course of submissions, well, semantically you could say that because the minister doesn't hold the information, they could answer that they don't have it and can't answer it. A question I made to officials was, well, okay, are there any grounds that the Under-Secretary could refuse to give it to the minister if the minister asked because they'd had an OIA? The answer to that is very clearly no. So the point that had been made both in the first reading and even tonight, that the information could still be sought through the responsible minister, is indeed the case. But we are going to take a principled position tonight and through the remaining readings of this bill that, in the interests of transparency, we could continue to argue the point that there is a distinction between not only the Executive Council and the Executive, there's a distinction between the Executive and Parliament. To include Parliamentary Under-Secretaries just helps to blur the distinctions under our Constitution sufficiently that we could find ourselves in a short period of time or a few years starting to have these things apply to other roles outside of the Executive as well as the Executive Council. But in the interests of serving democracy, serving transparency today, and doing so in a manner that is quick and easy, we have sought to support the officials' advice that we simply redefine what a minister includes under Mr Urufei's bill. That will mean that the Parliamentary Under-Secretary of this Parliament and any others will be captured. The Official Information Act will therefore then apply to that role. The public can feel secure that we're taking steps as a Parliament to give that greater transparency, and we will be supporting this bill from this point.
A 5-minute call on behalf of the Labor Party, Chris Hipkins.
Thank you very much, Mr Speaker. Mr Speaker,